Hello everyone, this is Robert Wieber, and this is my second attempt at recording my video for, for the examining complaints and answers uh, assignment this week. And the complaint that I actually found is out of the Arizona Superior Court in Pinal County, and this involves a wrongful death, gross negligence suit that was filed by Dina Das, who is the surviving wife of her husband, who was unfortunately shot by police, and she's brought a wrongful death and death suit against the officers and the county. And I'd like to go through this and apply the rules, even though this isn't a Tennessee case. I hope that I can explain everything to you. So we're going to start off with Rule 10.01, caption names of parties. As we can see here, the rule says every pleading shall contain a caption setting forth the name of the court and the county wherein the action is filed or is pending, the title of the action, the file number, and the designation as in Rule 7.01. In the complaint, the title of the action shall include the names of all parties, but in other pleadings it is sufficient to state the name of the first party on each side with an appropriate indication of the parties. As we can see here, this was filed actually with the court clerk stamp, which is another rule, and the signature of the court clerk as well. It was filed with the court clerk. This is the file number here that they've given this complaint, and it names all the parties, Dina Das and her children as part of the estate of the deceased. It names the sheriffs and I believe the two officers that were involved. And I noticed with other complaints as I was looking, they usually indicate the name of the judge on the complaint that was filed, and I believe the name here, Joseph R. Gorgini, is the name of the actual judge. And what I noticed with this particular case, or complaint, is it does comply with it does comply with a lot of Tennessee's rules. It gives the jurisdiction or the venue, and it places this particular case clearly the residents of Maricopa County in Arizona, and Pinal County must be as political subdivision in the state of Arizona. Caused events occur in the state of Arizona, which way the claims are subject to this of this lawsuit arose. And in this complaint, they give the jurisdiction of that, and I believe it complies with Rule 8.05, and 8.05 states sets out the requirements for stating a claim or defense based upon a statute, ordinance, or regulation, allows the statement of all claims the defense party has, expressly permits inconsistent pleadings. It also complies with Tennessee's Rule 8.01, provides that a pleading that sets forth a claim for relief must contain a short and plain statement of the claim and demand for judgment for the relief sought. The rule also authorizes demand for alternative or different types of relief. And and actually this claim that they've actually filed, it goes in great detail as to the general allegations they have here, where the two officers were pursuing the plaintiff's husband. Subsequently, there was a shooting that was involved where the husband was killed, and now the family is suing the police for willful and wanton complete disregard for his safety, in the situation, and is filed a wrongful death suit against the police department and the officers involved. And we could see, it's broken down here in each paragraph. Uh, all the allegations, action, defendant, name and unnamed conspirators. Um, it gives a notice of the claim, and it gives the different counts. Count one is a wrongful death suit, and they give all the reasons for that, or they break that down for um, their jurisdiction. So they're alleging count one is a wrongful death, the wrongful death of Mr. Bender, and count two is a gross negligence claim that they're filing against the officers. Count three is under 42 U.S. Code Section 1983, claim for excessive use of force by the officers against the plaintiff's husband. And then we have the actual, and I did notice with this in some of these pleadings, it does give the time and date, which I believe is consistent with Rule 9.06, which says time and place. For the purpose of testing the sufficiencies of a pleading, averments of time and place are material and shall be considered like all other averments of material matter. And averments threw me off a little bit, and from my understanding, it's like a statement that is made against another party. So if I make in this case, the plaintiff is making an allegation or a statement against the police officer, saying that they willfully and wantonly took the life of her husband in this claim. Okay, and I believe the end there was a little issue that I found, and what the Tennessee rule. Rule 11.01, the signature, it says in subsection A, every pleading, written motion, and other paper shall be signed at least by one attorney of record in the attorney's individual name, or if the party is not represented by an attorney, shall be signed by the party. Each paper shall state the signer's address, telephone number, and Tennessee Board of Professional Responsibility number, if any. And in this particular case, we have Dina Das representing herself pro per, which means she doesn't have an attorney. But I noticed that the complaint doesn't give her address or telephone number, and of course she wouldn't have a Tennessee bar number unless she was an attorney, or an Arizona bar number in this particular case, unless she was an actual attorney. And I'm not sure if the service of process would be connected with the complaint itself, or if that would be separate from the complaint. I noticed that on some of the complaints that are on file, they have that as part of the actual complaint as the proof of service, and for some reason this complaint doesn't have that. So I think with those two possible inconsistencies, this wouldn't conform entirely to Tennessee's rules of civil procedure in this particular case. I'm going to pause just briefly so I can switch over to the answer, and then I'll continue the video from there. So as we can see here is or the answer that I've actually found online. It comes from the United States District Court for the District of Maryland. It mentions the name of the plaintiffs, Brett Wade and Aaron Cheney. Foster is the defendant. It gives the case number. there is no clerk um, stamp on the answer, and I don't know if that would be standard um, even in Tennessee. That's probably a question I'd like to pose to if anybody knows. I don't personally know. I don't work for an attorney's office, so I kind of found that interesting. It does give a case number, so I'm assuming that the case itself has been filed. This is just in reference to that case, and it probably didn't need to be filed. It could have been filed directly with the judge and not with the clerk of the court. And if we look here, it does follow the same guidelines with uh, the rules. And if take a quick look here, there was a couple of rules in section rule 8.2 provides for the filing of the answer, which sets forth defenses to each claim asserted and which admits or denies the averments or statements upon which the adverse party relies. And we can clearly see here that uh, they've given a corrected answer, affirmative defenses, and counterclaims. So they've given a title to what the first part of their answer is. So the answer is the complaint, and what they've done is they've just taken it. It seems like from answering directly to each paragraph or uh, pleading from the complaint itself. They're either admitting or denying each claim, each paragraph from in reference to the complaint that they received. And we can see clearly, number one, defendant lacks sufficient information to admit or deny these allegations, and consequently they are denied. Count two, admitted except that the plaintiff's name is Aaron Colin Foster. Count three is denied. Count four is admitted. I really don't want to go through all these, verbatim. I think, it says in Rule 8.03, list affirmative defenses which must be raised in a pleading to a preceding pleading. Rule provides that the party relying upon a matter consulting an avoidance or affirmative defense must set forth the facts constituting such defenses in short and plain terms. And I think we can, and Rule 8.04 adopts general principle that averments in a pleading to which a responsive pleading is required are admitted when not denied or in responsive pleading. I'm not sure really what a responsive pleading is, I'll be honest with you. For special cases involve subject matter or person which might make the general rule oppressive are exempted from the operation of the rule. And 8.05 sets out the requirements of stating a claim defense based upon a statute, ordinance, or regulation. And I believe this does actually conform to that rule, because it, if I remember correctly, this does involve a statute. And I'm going to just kind of scroll down here. Unfortunately, I do have to apologize to everybody. This appears to be like a sexual battery case, which I didn't realize until actually after I started doing my video. But now that I have it, I'm going to just try and kind of move forward with it, because I'm lacking a little bit of time, unfortunately, because of my work schedule. I didn't have a lot of time to really work on this particular assignment. So I do apologize for me kind of jumping around. I'm planning on being a little bit more organized, hopefully with the next project. So in compliance with I believe it's 8.02, I'm sorry, 8.03, they list their affirmative defenses which may be raised in pleading to or preceding pleading, which is kind of confusing to me. I really don't understand this completely, but I believe this might apply to the affirmative defense that they're putting forth in writing here. And I believe there was a statute. Oh, I'm sorry, I'm wrong. And then they have their counterclaims, which I believe I'm not sure if this was actually, it doesn't say if this was served within 30 days. Tennessee rule under 12.01, the defendant shall serve an answer within 30 days after service summons and complaint upon him. A party served with a pleading stating a cross-claim against such party shall serve an answer thereto within 30 days after the service upon him or her. The plaintiff shall serve a reply to a counterclaim and answer within 30 days after service of the answer. The reply is ordered by the court. And it's not really clear whether this was actually served on time. Every defense in the law and then Rule 12.02, how presented every defense in law or fact to a claim of relief in any pleading, whether a claim, counterclaim, cross-claim, or third-party claim, shall be asserted in the responsive pleading thereto if one is required, except that the following defenses may, at the option of the pleader, be made in motion by motion in writing. And I believe that this is in writing, so I believe it does comply with Rule 12.02. And they didn't file any other motions, 12.03 motion for judgment on the pleadings, or 12.04 preliminary hearings, or a 12.05 motion for more definite statements, or 1206 motion to strike. Those weren't any motions that they brought up in this answer. They did their affirmative defense and their counterclaims too, and they actually did use the Rule 9.06, time and place, for the purpose of testing the sufficiency of a pleading. Averments of time and place are material and shall be considered like all other averments of material matter. And the other thing I did kind of have a question on, whether when the Rule 9 would be actually used, because it's kind of like dealing with capacity, special damage, petition for termination of parental rights, and it wasn't really clear to me how Rule 9 would actually come into play. Would it be just specific, would I do a, let's say, would it be a Rule 9 902 for fraud or mistake condition of the mind? Would that be a motion within itself, or would it be considered in as part of like a cross claim or a pleading within an answer? Is kind of what I'd like to really maybe learn, and that's a question that I have. So if we scroll down, it does give the time and place subsequent events, and it is asking for damages. The counterclaim, we have one, the first count is a battery, and the second count is assault. Third count, intentional infliction of emotional distress, abusive process, and defamation. And those are 5 counts, and they're asking for a jury trial as well, and they have a request for relief in their answer. And I believe they were asking for punitive damages and awarded appropriate injunctive relief, and it does comply with 11.01. And every pleading, rating motion, and other papers shall be signed at least one attorney of record in the attorney's individual name or the party is not represented by an attorney shall be signed by the party. As we can see in this one, this person had a uh, attorney on their case, and Matthew B. Kaplan, and he's got his Maryland bar number there. He gives his name, address, and telephone number, and as well his email address. And in this answer, it does include a certificate of service that the processor was Matthew B. Kaplan, and it looks like it was served on June 20th, 2017. And I think that's all the rules. I hope that kind of made sense for everybody. And I do apologize for kind of jumping around and not being what I feel is a little bit more organized. Um, but that is my video, and I look forward to everybody's answers. If somebody could help me out with that Rule 9 and give me a little bit of feedback, I'd really appreciate it. Thank you. Take care.